Good morning, friend. We are discussing about the weekly focus magazine, or the 2 or 3 pages in the whole discussion of the one topic that is given by the vision itself, and that is of the 21 session in which they are providing before a month. I think November they are starting, and till 10 December they are submitting and completing that 21 episode of these things. Let's see the whole. The topic is related to the constitutional morality. What do you mean by constitutional morality? If you're talking about the constitution, what do you mean by the constitution? Constitution is a book or the organic law of the country in which the sum of the provision, how the government would be there, which type of government should be there, how these institutions related to the political power, related to the economic power, what is the relationship between the state and the center, how much the power state contained. This type of provision are given basically in the constitution or the jurisdiction area wise, you can say that in a more particular way. And in general we can say the relationship between the all organ of the government, at the same point of the time the power of the state itself. So that is the meaning of the constitution. If you are talking about the morality, morality is nothing but it is related to the ethics of you, in which a person or individual is believing what is right, what could be the wrong. That is his opinion, in which he say that will be right, that is not right. That is the whole case of the constitutional morality. Constitution is nothing but the constitutional provision, and how it means that we are judging at the prism of the constitution and at the morality that are depicted in the person itself. Right? I think it is clear now. Okay, let's see the whole topic. Number first line, they are said the judiciary as an interpreter of the constitution. See, you are very well known that Supreme Court are given in the Lakshmikant book, where the said judiciary was an interpreter of the constitution, who are the guardian of the constitution, that is the president, right? Let's see the judiciary as an interpreter of the constitution. Whatever the line, what is the meaning of this line, had the contextual basis of the space and time, and these are changing as per time is changing. So that is the thing. The judiciary, I am really I again repeat it or reiterate it. The judiciary was an interpreter of the constitution, has effectively used the principle of the constitutional morality to overcome the age-old laws. Age-old laws is nothing but the whole system in which our own society in a Rigveda medieval India period are living, which needed to get reformed with the changing time and evolution of the society. As the evolution of the society is happened, as the time is changing, we have to adopt with the new situation created by the different technology and different cultural context that we are existing. Because you can, for example, you can say the British context, the Dutch context, the Syrian context, there is always be a type of a context we can see in our own life. For example, the McDonaldization of the food habit, that we are dependent upon the junk food because of the life that they are facing in the industrial time era. We are also facing the same situation in today. So that is the reason why we are aping or emulating the thing, because they are already do it. So we are doing that thing because they already had done it basically. The court has applied different facets of its progressive and transformative doctrine in a number of cases, some of which may possibly be counted as the finest and the seminal judgment. So, see how the people see, but the whole thing is there. The judge also of the Supreme Court itself is a time framing member, in which they also cultivate their thinking at the point of their studying. So they have a same knowledge that they are studying in the I think 70 or 80 years ago, or I think 70 or 80, forget about the 70, 80, but you can say that the 40 and 30 basically, you can say in a more precise way, in a particular way you can say. However, at the same point of time, many claim that the application of this doctrine amounted to judicial overreach and is thereby pitting constitutional morality against the societal or a popular morality. It means that sometime whenever judiciary give its decision, it overreach the earlier norms that are existing at the societal level. So that is the whole they wanted to say. Right? The doctrine came in for a heavy criticism after the Supreme Court's Sabrimala judgment, because there is a much more interference through the judiciary, by the judiciary basically, through various judgment in which the whole morality of the question are questioning. So that's why these are now much more pronounced at any point of time in the history of the judiciary or the social or the Supreme Court, you can say in a particular way. I become the subject matter of discussion, especially after the Attorney General of the Indian Constitution criticized application of the constitutional morality doctrine as a dangerous weapon. So, see, in which Attorney General, that is the member from the government itself, who said that the constitution morality doctrine as a judgmental or a dangerous weapon. How the well qualified person say like that? Let's see. Following this, the task of the defining constitution morality has been referred to bench of the 7 judges of the Supreme Court. But here the whole topic of the natural justice you are studied in your class, or the Lakshmikant class, in which you are studying about the natural justice case in which the person could not be handle their own case. There should be a provision to listen the other member also. Second thing, I think there should be a limitation of the power, or the same member could not be listened, in which they are so that the first principle that are overreaching the third. Anyway, dangerous weapon I already talked about. Following this, the task of the defining the constitution morality has been referred to the bench of the Supreme Court judge, and it defines, it decay the principal justice of the natural justice. Against this law backdrop, it becomes crucial to understand what is meant by the term constitution morality. See, one thing is said that the constitution morality is the way how the societal norms are or changing, are changing basically. But at the same point of time, when the government member itself said that the constitution morality is the dangerous weapon, he is the qualified lawyer basically. And how we can say, we have two views about this thing, the constitutional morality, where the question is rising whether it is right or not, it is beneficial or not, in the long term it is beneficial or not, and how this whole system question the separation of the power and the check and balance that are existing in any form of the government, or any democratic form of the government basically. That is the whole topic that we are discussing, in which first we define the constitution morality and we are itself defining the things. So I am just going through and give you some detail or insight that I was thinking with this the same point from the topic itself. Let's see the thing. Against this backdrop we are talking about, it becomes crucial to understand what is meant by the term constitutional morality. That is the whole thing that we also wanted to know about the thing. What do you mean by the constitutional morality? Let's see. And what is the significance of the doctrine in the present time, and how the concept evolved over the period of time, and how it's interpreted by the court. What are the grounds on which the application of this doctrine is being criticized, and what principles should guide our approach towards the constitutional morality in the future? Though this doctrine will attempt to answer this question, but you have your own insight. Let's see what is the constitutional morality and what is significance and how does it work. What the element of the constitutional morality, in which the first the thing that rule of law as per the article I think 14 and 15 is said that the rule of law should be prevailed. No person has an overreaching power over any of the institution of the state, and all persons are equal in the eye of the law. So that is the whole principle of the rule of law. There is all person has the same equality there. There is no partiality or prejudices against the rich or the poor. That is the thing, or on the basis of the any of the material, for example gender, there can be, religion can be, race can be, that is the various factor or ethnic group you can say more precisely in place of the race itself. Next is the social justice should be there, right? So that it has contained the element of the equity, in which the all, for example the poor who do not know the law, so first he should be aware by the state itself. If the state is failed, the we cannot give the same amount of a type of क्या कह सकते हैं उसको सजा. Okay, forget the meaning. Let's see. Next is the preamble. The preamble is the constitutional morality. It can be the way how the preamble can be act as a constitutional morality and as an interpreter of the constitutional morality that lies in the constitution itself. The word and the philosophy of the constitutional maker we can find easily in the preamble. So that is the basic framework in which the preamble are deciding the whole constitutional morality, and it is the source of the constitutional morality that lies in the constitution itself. Next, the right to equality. Right to equality, I already told you about. The poor people cannot give equal amount of conviction. You can say conviction. I forgot the meaning of the word, that is saja, or the torture you can say. Okay, equal amount of torture, yes. right? So right of equality should be there as per their social economic condition that are people lying, whether it be aware or not aware, whether they are intentional or non intentional, that depend upon all the things. Next, the individual liberty. Individual liberty should be there. It should be focused the individual liberty. It means that the individual liberty are at the paramount importance in case of the constitutional morality. What does it signify? It signify that the individual liberty has an important role whenever the question of anything that are existing at that point of time, when we choosing some person or the some organization at this point of the individual liberty. So individual liberty get the more preferences as per the constitutional morality, and it's the basic component of the constitutional morality. Next is the due process of law. Due process of law is nothing but the whole process, the law making procedure are happen, and it is should be happen through the power that is given by the constitution itself to make these laws. First thing they are checking. Second thing, is it tally with the constitution or not? That is the thing. Number third, is it the good or not as per the new way of the living or the modernizing value. For example, rationalization, egalitarianism, equality, rationalism, like of that situation are existing at that point of time, and that are, it means that a point of time that is much more prevalent. In that prism also we check the whole constitutional morality that lies in that person, right? Next is the freedom of choice and expression. So that is the basic thing. If you can correlate it with the individual liberty to the freedom of choice, because whenever the freedom of the choice and expression is given, the individual liberty are ensured by, you can say, the vice versa is situation or happening there. Okay, let's see what is the constitutional morality and what significance does it hold. Let's see the thing. The constitutional morality is not defined anywhere. However, there are many different notions that are existing, and on that basis the judiciary give its judgment. Basically, it means that the adherence to the core principle or the constitution in democracy. See, for example, basically you are listening about the basic framework of the constitution should not be changed. That is the whole case or the crux of the the Keshavananda Bharati case basically. Okay, it basically means adherence to the core principle of the constitution in a democracy. Moral obligation of an individual to uphold the constitutional value with utmost dignity without any compromise and being faithful towards it. So we could not have any doubt about the constitutional maker, the values that they are wanted to propagate through these core of law. It means, see, whenever we talking about the constitution or the constitutional morality or the constitution, that laws are made in the constitution, that is the ideal situation that should not be replicated in the same the word they are written in and the spirit that we are implementing. There is somewhat of a gap because of there is a human behavior. So because the implementation lackness, see, we are not a robot actually, right? We have some gap, and because of these some gap that make different country differently. For example, whenever there is a constitution that they are providing, when they are implementing in a spirit and the word that they are providing through the constitution itself, it has much more democratic principle that we generally found in. For example, USA has a constitutional law, the constitutional machine, they are much more evolved with time, but at the same point of time they are implemented in a well spirit. So that is the whole situation that lies there. Let's see the next thing. It is thus beyond and the final interpretation of the text of the constitution and dwells in the spirit of the constitution, in which the both individual and the collective interest of the society are satisfied. Yes, that is the whole main basic aim of the constitutional morality. It is thus beyond the literal interpretation of the text of the constitution that dwell on the spirit of the constitution. See, how we interpret the constitution that dependent upon that person that are the judges there. When the one person has some judgment in the another place, Supreme Court itself dismantle their own reconsider their own judgment and give the different judgment as per the time and the space that they are dealing in with. So that is the whole situation. We are going with the literal interpretation of the text of the constitution that developed the spirit of the constitution. What is the spirit? What is the constituent of that spirit? Is nothing but the element of the moral constitutional morality, in which the rule of law, social justice, preamble, right to equality, individual liberty, due process of law, freedom, choice and expression are given, in which both, and the main goal of this whole thing is nothing but the individual liberty should be ensured. At the same point of time, status quo should be maintained in the society. That is the whole situation that we are wanting in. Okay, Let's see the next thing. The doctrine is still in the nascent stage in India. See, we are we are now a developing country, and where we have a much less evolved type of institution which we govern in or we implement the constitution. So there is always be a lacuna or the gap there, the word that are written in the constitution itself and the spirit that they are implementing, because the lacuna in the whole process of the getting the education, the awareness level of the people, there is a various reason behind that the whole situation direct existing at in India basically, and that's why they are saying that it is a still nascent stage in India and has been evolving over a period of a time. In a recent time, for example, the doctrine has been invoked by Supreme Court in India for striking down laws which can termed as the manifestation of the popular morality, and in process has required new meaning and interpretation. So, see, for example, if you are talking about the changing, how the society can be changed. Society can be changed through the internally. They are aware so much so that they can make their decision themselves, and they are adopting those things that we are borrowed from the Western culture or the Western civilization. The good thing of the Western culture in the positive way. I am using the word Westernization, the modernization. You can say that basically. At the same point of time, the meaning or the how the society is changing is the exogamous, when other community, other laws, other rules made by the government imposed by the state to the people. So that is the whole exogamous, and exogamous is very less. For example, we see in the colonialism period in which people are giving some importance to the British people, in which we also changing with them as per the thing. So that is the whole situation there. So this is the way how we can change. But with these things, when the British are gone, then the political power that they have a law making authority, in which they do not want it to be the far away or deviate from the social norms. So that is the need of the judiciary to come up with the new social norms so that it can be synchronized with the new modern laws that are existing in the more evolved society, where the constitution are implementing in a spirit, right? That's the whole idea of why the Supreme Court come up with these things, but not the political power, and that's the whole situation. Then what is the significance of the doctrine? Let's see the thing. Safeguard, the uphold the enforcement of the law in the country. So that is the basically theme. For example, constitutional morality basically mean to how or bow down to the norms of the constitution, not act in the manner which would become violative of the rule or the law of the reflecting on the action in an arbitrary manner. As the doctrine tends to caution both the citizen as well as the government and it promotes people to be an active participant of the system and fight its inequalities and non-constitutional element that are found in the society. That is the basically aim of the whole situation, that the constitutional morality. I again repeat it for you people to understand in a very better way, because already question asked on the basis of this topic. First thing, second thing, essay also asked, because in which we are discussing about the constitution and the moral constitution and the customary morality laws that are existing in the different part of the society. So you have to give a brief discussion about this thing, and you should know about all these factors. What the significance? Let's see without any delay. Safeguard and uphold the enforcement of law in the country. See, constitutional morality, because basically means to bow down to the norms of the constitution. So it is the main aim here. The spirit of the word that are written in the constitution itself should be implemented in a very great way, and not to act in a manner which could become violative of the rules or reflecting on the action in arbitrary manner. See, next thing that I think should be discussed, that is the promoting and reinforcing the democratic ideals of the nation. So the basic idea here is that whatever the constitutional thinker wanted to our country to be governed like that, we should be maintain these things, and we should be promoted these things to the constitutional morality that that is not basically written in the constitution itself, but the main basic aim of these things to write is to be implemented. So that we can say that the implement of the basic constitutional morality itself. Let's see the whole idea here, that they reason wanted to give some insight there. The doctrine promotes congenial cooperation and the coordination of all the stakeholders, especially among citizens and the state, to pursue constitutional ambitions. Thus, it is a point to the idea of propagating the trust of the people in a democratic institution. Moreover, since the concept of the balance or the places an obligation on the part of the state authority to conduct themselves in accordance with the constitution, so that for example, DPSP is there, fundamental right is there, fundamental duty is there for the citizen itself. It translated to the people, reflecting the authority of the state, so long as they act within the foundation of the constitution. As I already talked about, for example, judicial review is there, judicial overreaching also be found there whenever there is a much more power that are exercised by the judiciary itself. So that is the whole situation, that the basic checks and balances also found between the government and the executive and the legislature at the parliament level. Also the judiciary many times are also evolved or the overreach the power of the the other organ of the state, right? We already discussed. Next thing, what the significance we are discussing. See, earlier we are discussing about the constitutional morality, then we are discussing about the element of the constitutional morality. At the same point of time, next we are discussing about the significance of the doctrine. Number third significance we are discussing about. Next is the bring about the positive transformation in the perception of the societal or the public morality. See, bring about a positive transformation. Our aim is nothing but the constitution. Why we implementing? Because our society would become a evolved society, or not a evolved but the developed society, basically, where the all modernization, all the equality of the constitutional element should be reflected in a society that is synchronized with the whole society and the governing principle of the society, basically the positive transformation in the perception of the societal or a public morality, right? The principle of the constitutional morality can be used for the reading down laws or statutes which are inconsistent with the incumbent time. I already discussed it about, because always society wanted to be a status quo. There is a transition period in our society, and with the economy development, with the come up with the social development, and when the social development, economic development, the nascent phase, there is some lag between them, where the peripheral are changing but the core are not changing. But the core, when they are changing, they take some time, and the whole time period of that time taking of that core to change it to the peripheral, there is some external forces that should be governed, so that the individual liberty or the individual way of the expression and a much more evolved personality or the individual can be get it out. That is the main and the whole game of the constitutional morality that we wanted to be implemented in our society. That is the whole basic aim over there, right? For example, they are so giving the example, for instance, in passing a law prohibiting sati, right to life and the dignity, was passed to the Indian widows who were the earlier considered to the harbinger of the misfortune and ill luck. So the whole situation are changing like that. Earlier we said that the widow has a harbinger of the misfortune, but at the time when we are recognize their right, we are recognizing their vulnerability that they are facing as a part of the society, then we are stand with the society as a whole when we are implementing the constitutional morality there. So that is the basic and the whole aim of the constitution, that our society become equal, our society become a liberal, our society become a democratic, our society become a rational, our society become egalitarian. That is the whole basic aim and the principle that we wanted to focus in. Let's see that thing. However, after the passage of the law, there has been a clear change in the public mindset, which also led to the promulgation of the more right to them, such as those of remarrying and getting educated post their husband demise, right? Next, the promoting diversity. See, that the basic and the type of uniqueness that are found in the constitution itself, right? Promoting diversity. Word is very famous, and many people are not know about what do you mean by diversity. And diversity, if diversity is there, what is its significance? Anyway, promoting diversity, helping to make the society more inclusive. For example, integrational way of the tribal society that they are governing, that is the more integrative way of the society, in which the all member of the society can take part in the evolution of the society and the economic development. They should be part, and the whole aim of the but we are recognizing the cultural element that they are found, so that they cannot feel alienated at the whole criterion, and basically the diversity should be there in the society. Let's see. Constitutional morality is especially significant for a vibrant and diverse country like India. Why it will be so? Why it is special for India? Let's see. Constitutional morality is specifically significant a vibrant and a diverse country like India, which had got heterogeneous population with so for the sub-classification, the caste, religion, color, sexual orientation, languages, gender, etc. Since, as per the Anthropological Survey of India, where 74500 different type of population found in India. So you can say the diversity in the population race of the India itself. Okay. It recognizes this distinction and non-homogeneity and promote diversity, helping to make a society more inclusive. Next is the akin to the basic doctrine. See, together when we are saying about the basic doctrine, what is the aim of the basic doctrine is nothing but we cannot change some part of the constitution in which our basic principle are lies in, or the constitution maker wanted to make our country like in. So that is the whole basic. Some part are so important, so basic, if they are changing, the whole criteria, the whole meaning of the constitution is itself changing. So that is the basic aim, basic given structure of the judiciary to the basic principle, right? Together with we are talking about the basic structure doctrine, constitutional morality is known as one of the constitution silences. Like the basic structure test, it imposes implied constitutional limit on the government and ensure that government action do not violate the spirit, soul or the conscience of the constitution. So that is the main aim. Then moving toward the achieving the constitutionalism. Constitutionalism is nothing where the government power is limited through their various imposition given through various acts that are written in the constitution itself, where the government has limited power because of their any other thing. For example, fundamental right in the part 3 of the constitution has the basic example we can achieve through the constitution. We can achieve constitution through these basic right. Let's see the concept of the constitutionalism in India, because there is in 2020 there is a question about this whole idea. That is the constitutional morality. What do you mean by the and basic structure? What there is relationship? Let's see. Constitutional morality is the latest in the series of the various silences of the constitution, right? Of which basic structure was the first in 1973. The relationship between them can be explained through the following. Let's see. While the concept of the basic structure was empathetically discussed at length in Keshwanand Bharati case of 1973, and the judiciary continued to define its scope and characteristic with the new interpretation with the new cases, but no constitutional case has so provided clear interpretation of the basic structure. What is the basic structure? It means it depend upon the case to case basis, where the constitutionalism should be held, because we have to limit the power because they have much more power as compared to the normal people, and the basic aim of the constitution is the whole people in the Indian subcontinent, or the not Indian subcontinent, because there are various countries. Anyway, though the Indian people should have equal power, but there is nothing some power given to the some people in a comprehensive manner, so that it can be, when exercised, it can make other people so vulnerable because of their power they exist. The power gap should be between the people and the government should be exercised. Because of these things, basic structure come into the wall as a wall, in which the government has some limited power, right? I think clear now. For next is the concept of the basic structure is mostly used to nullify the constitutional amendment which go against the fundamental spirit of the constitution. So it is the whole say. But the constitutional morality, on the other hand, has emerged as alternative jurisprudential concept that can use to nullify ordinary legislation also, to avoid the weakening of the sanctity of the basic structure concept. Let's see the concept of constitutionalism in India. In any democratic country like the Indian case, for example, constitutionalism is manner in which the institution of the government conduct themselves to achieve the very objective of the constitution. So, but the aim of the constitutionalism, the government conduct themselves so that they can they can materialize whatever the things are given in the constitution itself. Constitutionalism render political and ideological aspiration that contain to the philosophical soul of the constitution, with the primary objective to transform the societal progressive and inclusiveness. It does not only include the recognition of the right and the dignity of the individual, but also propagate the fostering and development of an atmosphere where every individual is bestowed with the adequate opportunity to develop socially, economically and politically, and thus dissuading the society from indulging in any type of discrimination so that they are aiming at. Let's see the next topic, in which we are discussing about how the concept of the constitutional morality is evolved after the constitution itself, after the enactment of the constitution itself. Let's see the thing. First is the conceptual definition given by the George Gorte. The concept of the constitutional morality was produced in the British classicist named George Gorte in the 19th century. In his book, History of Greece, he described his constitutional morality as a paramount revenue. I'm really sorry, whatever I wanted to say, that is not. See, constitutional morality as a paramount reverence. Paramount is nothing but at the apex level, at the highest level, you can say, at the paramount level. Reverence is nothing but the respectful that we are given to that thing for the form of the constitution. So it is the respect, the maximum respect given to the constitution, that is the main aim here, the constitutional morality. And what is the respect given? Respect given is, it means that the whole idea of the constitution should be implemented and should be respected by the every individual, should be aware them through various educational processes at the whole aim, right? It is essentially implied coexistence of the freedom and the self-imposed restraint. It means that while citizens would respect the constitution and obey constitutional authority, they would have the freedom to criticize those constitutional authority, and non-constitutional authorities would have to within the limits, so that the imposition of the law should be maintained. Let's see the empirical perspective of the constitutional morality. It is important because this question is already asked, and that is the, let's see. In India country, for example, the word constitutional morality was propounded by the Dr. B.I.M. Rao Ambedkar, in which they are said in 1948 in parliamentary debate with respect to in the detail of the administration, including the draft constitution. So I think that is clear now. Ambedkar, drawing on the work Joe Gorte, formulated his understanding of the constitutional morality as an effective coordination between the conflicting interests of the different people and administration cooperated to solve those issues or conflict or the dilemma between what we are listening it about. For example, when we are saying about the individual liberty and the constitution and the institution and the society at large, then where we should go. If we have no anything, the constitutional morality come into play, in which they first give to a balancing approach, first thing, second thing, then they give to the collective approach in which the whole society should be benefited, but the individual liberty of that particular person in which they are opposable, their consent and their liberty should not be obliterated by the any of the constitution or the any of the part of the constitution or the institution that are lies under the constitution or the government or the executive or non-statutory body that are the law of land now, right? According to him, constitutional morality was an answer to existing disparity in the society, and the doctrine primarily translated into respect among stakeholders in a republic of the constitution democracy as an accepted in governance and administration. I think that is also clear. Let's see about the constitution differences. What is you mean by the constitution differences? Let's see. The term constitutional morality is not found in the Indian constitution, that is the thing. Nevertheless, we find mention the word morality in conjunction with the public order in the constitution at various places, and where the public order is found or the public order is found in the constitution or the article of the constitution. Number first, the for instance fundamental right available under article 19a clause a, in which the power is given to the people, they can express themselves. At the same point, if the media can express them, there is the power given in the 19.1 clause a. 19.1 clause c. 19 clause 1c is, I think, or the association like that, may be reasonably limited by the state on the ground of the public order, decency or the morality, and thus under article 25.1 and 26 are the subject to public order, morality and health. For example, post 1950s till the present, how they are evolving. Let's see. There is nothing to be much more. Let's see. In 1950 or the post 1950, the concept of the law in somewhat dormant state, though, because there is a much more priority than they are, and people are not even interested in. Second thing, the case is much more in the Supreme Court, High Court, and the judiciary or the subordinate level lies in the case related to the land, and the whole burden is dependent upon the land, and people are not aware itself of the constitutional morality that like that the situation. Though it was used in the passing reference twice by the Supreme Court in Keshavananda Bharati case and the first judge case, SP Gupta case versus Union of India. It was the first time in 2010 in a Naz Foundation versus the government of City of Delhi, where the term was used in the anti-ethical way to popular acceptance and standard of morality. In this form, a precedent was set in the court itself to disregard societal norms, stigmas and limitations that are lies in the societal term in today also. So, the limitation while accessing the action of the state. For instance, for example, in case while deliberating upon the issue of the decriminalization of the homosexuality, then a criminal offence under section 377 of the Indian Penal Code, the court took cognizance the ideal of upholding the constitutional prevalence in which the liberty, their expression, their dignity are lies there. Principle rather than the societal perception with regard to the legitimacy of the same-sex relation at the same point of the adultery that are found in. The term continued as the judge started giving the rationale of the constitutional morality in many landmark judgment, and where the concept of the constitutional morality has emerged and it become the favorite question of the UPSC itself, because Supreme Court using it many times, and people should know about the what they mean to the constitutional morality and what it is said standard for the bureaucrat in the country, and what is the importance of the bureaucracy for the knowing about this concept of the morality or the constitutional morality in general. Okay, the trend continued as the judge started giving the rationale of the constitutional morality in many landmark judges. Therefore, that is the whole case that is same. Let's see the landmark judgment that changed the contemporary interpretation of the doctrine. Let's see the thing. For example, Navtej Singh Johar versus Union of India 2018 case in which the LGBT community given the power. In the second case, let's see Joseph Sahin versus Union of India, where the upholding of the gender equality should be there. Number third, government of City of Delhi versus Union of India. The court was decided to what part does the Lieutenant Governor of Delhi, where the constitutional power that lies with the the popular vote of the government that are found in the Delhi itself. Next, the India Young Law Association, that is related to the, I think, Sabrimala judgment, in which the Lord Ayyappan is violated the 4 key constitutional morality tests, which include the justice, liberty, equality and fraternity. In this court noted that the word morality in Article 25 and 26 must mean constitutional morality and not popular morality, and the existing structure of the social discrimination must be well weighted through the prism of the constitutional morality. That is the important statement there. The judgment has been interpreted as the biggest blow in the public morality and also been criticized in the religious prohibit among the others. So that is the whole situation there. How people are reacting, that also be important, because all people are not happy with the some kind of judgment, although they are part of the same society. Anyway, on what ground has the doctrine have been criticized in India? What is the reason why the constitutional morality is discriminated? Number first, lack of literature and clarity on the concept of the constitution. See, we are already discussing constitutional morality does not give in the constitution, that is not defined the constitution itself, but the Bhimrao Ambedkar itself said in 1948 as a different story. Although as there is no explicitly mention the term constitutional morality in the Constitution of India, there is no fixed definition, so that we can found in the constitution itself that has been attributed to it. It has been left on the discretion of the individual judge to interpret the essence of the doctrine and apply it to requisite situation. This may get privy to subjective interpretation by the Indian judiciary having different perception. Many times there is a scene that they are restored their own judgment. What do you mean by this thing? That they people are not even aware about the things. People are not clear about the things. The judges are themselves do not have a clear-cut perception, although they have a same study, they have read the same laws, but that depends upon the time and the situation, but they are not even following these things. Anyway, for instance, in Sabrimala case, the majority opinion held that the restriction imposed upon the women in age group 15 to 10 to 15 years is against the constitutional morality, while one dissenting opinion found that the constitutional morality will require that every single individual would have the right to his own faith and nobody can interfere with it. Court cannot interfere their own right that they are entitled to. So read the whole story. Next, encourage judiciary supremacy and activism by the court. I already talked about overreaching nature of the judiciary, that the faulting point the constitutional morality. One people has some laws, some views about the same thing, but the other people they have the same place, but they have different view. How they can be perceived like that? Anyway, upholding and promoting the democracy by using constitutional morality encourages judicial activism by the court, leading to intervention in those functions which are to be primarily undertaken by the legislature. This makes the doctrine violative of the basic tenet of democracy, that is the separation of power between the judiciary, legislature and executive. This become possible with the Supreme Court interpretation of the Article 140 of the Constitution. This article deals with the power of the top court to exercise jurisdiction and pass order in the spirit of doing the complete justice. So that is the whole story. Next, the hinder the organic and the natural development of the society. See, it is the when I already talked about how the social change has happened. First thing is internal is happened, second thing is the external is happened, and that the constitutional morality is the external source where it govern, it wanted to synchronize with the societal development. So that is not the good, I think that is not the organic, basically they wanted to say. Hinder the organic and the natural development of the liberalism or a rectification of the wrongs or the ethical ills of the society, as it vests power in the hands of the court to implement a top-down approach of the ideal or the morality front. So it has less significance or the faith in that the whole values. It also indirectly reflects a lack of faith on the true ideals of democracy, where they say that the people are aware, people should be aware, people should have informed choice, people should have listened, but they are the basic tenet of the democracy itself, they are opposing it. Next, the created distrust among the public toward the organ of the state. The top-down imposition of the constitutional morality by the court, which is unelected, first thing. Number second, it is autonomous body, may instill and encourage a general distrust among the public toward the legislature and the executive. So the whole case act as a counterpoise to public morality. See, whenever there is a the standards set in the society or the old society, whenever they are imposing and when they are contradicting behavior, there is a clash in the society. Some people are focusing one thing, second people are opposing same thing. That is the whole story that lies, and that is make the public polarize basically, or the making the two polar there. The motion of the public morality is essential based in the societal notion of the right or the wrong, and not based on the core principle of the constitution. As a result of several occasions, the decision based on the public morality at a loggerhead with the decision based on the constitutional morality. So the whole thing. Also, the notion of the morality is extremely fluid and subjective in nature, and they are dependent upon the interpreter of the constitution, and that is the Supreme Court judges. So that is the whole subjective in nature, and how we can see we can implement subjective nature of the judgment in which they are itself is not clear, and how the implementing agency get clarity where they have to go, because there is a when they are reconsidering their own judgment, there is ambiguity found. They should not be there like that. As a consequences, court have argued that the judgment morality should not take precedence over the public morality. So that depend upon the case right now, right? So we cannot say. Okay, on what ground has the doctrine been criticized in India? Let's see. For example, first is the lack of literature and clarity on the concept of the constitution. We already discussed it about. Okay, public morality or the constitutional morality, which is better suited for the restriction the fundamental right. So अब आपको ये बताना है कि जो public right है, public morality है basically, और the constitutional morality है, कौन सा, which one is better basically. Why using the notion of the constitutional morality or the public morality can be problematic. See, under Article 12 of the Constitution, the power to impose reasonable restriction of the fundamental right are vested with the legislature and executive, not with the judiciary. So that is the whole case. This clearly asserting that the judiciary cannot limit the fundamental right through the doctrine of the constitutional morality, but at the same point of time they can be done through the executive and the legislature and the notion of the public morality under Article 12 of the Constitution. Next, the moreover, it also argued that the fluidity of the public morality is the essence of the societal, making more moral progress through the social evolution, right? Subsequently, stating that this moral progression should not be overpowered by any of the constitution thing like that. Next, why basing decision solely on public morality is ill-advised. Let's see. Although the idea of a public morality seems to be democratically more suited for the restricting of the fundamental right, limiting them solely on the basis of the public morality is rife with the subjectivity. So that is the whole case there. Since every dispensation of the government may have its own definition of the public morality, so that we should not go with the public or the public at large, because there is in public itself they are also be divided. Can there be a balance? Yes, bilkul yes. There is a one case that we are founded after the 70 year of their implementation of the constitution, where the one case of the Subramala case of 2018, where the constitutional morality and the public morality came into conflict, and when the whole concept of the constitutional morality are emerged and evolved in a very greater way. So that is the whole questioning there. But we cannot say that the constitutional morality is nothing. That it should be there. That it is the ideal condition basically, but the societal norm and the changing that are happening in the transition period of the society should be taken care of. Let's see. Can there be a balance? Bilkul. Constitutional morality may be applied by the judiciary to access state action which are substantially unreasonable or violate of the spirit of the constitution. This will indirectly address the issue with the usage of the public morality by minimizing the possibility of the unreasonable decision making, while simultaneously providing a space for public morality to the natural evolvement. Let's see. Okay, next topic that we are discussing about the what principles should guide our approach toward the constitutional morality in the future. Let's see. The first, constitution itself, constitutional morality to be complemented and supplemented by the judicial values. So what do I mean by this thing? Let's see. Constitutional morality is a sentiment to be cultivated in the minds of the responsible citizen, which is to be promoted by an individual or independent judiciary embodied with the values and ethics that they should be have. Let's see. Where the judicial diligence is absent and judicial integrity should be questioned, constitutional morality cannot be upheld. So that is the whole case, and that lies in the ambiguity when there is so much sorry consideration and how people can be trusted on them, and there is an ambiguity find in the mind of the implementing agency there. So that should not be there anyway. Standardized yardstick should be evolved so that the old people or the old judges should be have a same set of mind in which they can give the decision. So that should not be reconsidered, and the problem of reconsideration I already talked about. So that there is no scope for the illegal inconsistency, a jurisprudential analysis the need of the hour when judges will be see constitutional morality not just as a tool to nullify the particular legislation or the executive practice, but to establish the vocabulary in the constitutional law as a philosophical concept which is a specific meaning at the scope in the constitution itself. Next, the need for the balance application, that is also be the very much requirement, because there is a public morality there is a constitutional morality, there should be balance so that they can live in harmony. There should not be so protest against the constitution so that we can disband the constitution itself. There should not be so protest in the public morality that the public morality should be changed. No, not like that, but there is a synchronizing effort like that. Let's see the vision explanation. Constitutional morality may be evolved on the basis of the provision of the constitution to question the conduct of the state and to identify the meets and bounds within which the state must cooperate or the operate. However, it cannot be used to emasculate the discretion and the prerogative of the constitution vested in the state to define the public morality by virtue of being an elected body. So there should be a constitution so that the state or the elected body of the state should be have say, because they are also the elected and the representative of the public itself. So they should be have a say in the defining the public morality. They should not be completely dependent upon the non-constitutional body. Firstly, no, sorry, constitutional body should be there, but the autonomous body where they do not have a elected representative there. There should be a type of a correlation between the constitution and the elected body there. Commitment in the ideals and the aspirations of the constitution. For example, preamble we are discussing, in which we are seeing the element of the constitutional morality. So the preamble or the values that are found in the preamble should be implemented with the heart and spirit, with the word and spirit, sorry. Okay, the democratic values survive and become successful because the people at large and the person in charge of the institution are strictly guided by the constitutional parameter without paying the path of the deviancy, and the maintain institutional integrity and the requisite constitutional restraint through their action. In this direction, awareness must be created among the common public regarding the right as well as their responsibility toward the country. What is the conclusion then? The requirement of the certain principle and limitation for the application of the constitutional morality cannot be denied. However, the viewpoint there is no completely resolve the aspect of the constitutional morality, but rather harmoniously constructed in order to better the functionality of the judiciary and the judiciary embarked upon them. The court can thus employ constitutional measures as an effective tool to interpret the right of the conferred on the individual by the constitution. Let's see the topic at a glance so that you see the whole thing in which we are discussing about this topic. Let's see the first we are discussing what is the significance that the safeguard and uphold the enforcement of the law in the country. Second, the promoting and the reinforcing the democratic ideals of the nation. Number third is the bringing the position or the transformative perception in the societal norms. Next, the practically act as an equivalent to the basic structure doctrine, so that the government power should be restrained in order to have a constitutional morality. A step toward achieving the constitutionalism. Then the constitutional morality is nothing the concept not defined anywhere, and many notions are the same but that dependent upon the judge of the Supreme Court. It basically means the adherence to the core principle of the constitution and that are provided in the tits and bits in the constitution itself, where they are collecting and they are using these things as an act and a prism to interpret the constitution. Or the evolution step. For example, the Bote person defined the thing at the same point of time, 1948, that Bhim Rao Ambedkar also deciding the thing. He described CM as the paramount reverence for the forms of the constitution of the land, which essentially implied a coexistence of the freedom and the self-improved restraint. Ambedkar's perspective of the constitution is the effective coordination between the conflicting interests of the different people and the administrative cooperation so that the conflict can be resolved there. For example, if you are talking about the after 1950 till present, various landmark judgment, for example, this constitutional morality judgment with the Naz Foundation with the versus the government of NCT of Delhi in 1920. 2010. Criticism of the constitution, lack of the literacy, encourage of the judicial supremacy, hinders the organic and natural development of society, create disrespect or the distrust among public, act as the counterpoise of the public morality whenever there is a constitution and the public morality are collided. Next is the principle that should guide future approach toward the constitutional morality, that is the constitutional morality to be completed and supplemented by the judicial value, so that they have coherent and the monochromatic views about the things, so that they should not be provided an ambiguity with the any ambiguity in the society or the implementing agency in general or in particular. A standardized definition of the concept should be evolved. Need for the balance and implication of the doctrine of the judiciary, commitment to the ideals and the aspirations of the constitution by all the stakeholders, so that we can enjoy our constitution in a very better way. By this we are ending the session. Thank you.